Hello, everyone. Welcome to panel 2.
We're waiting for Macy.
We have I'd like to introduce for panel 2 Professor Donald Langevort, Professor Jonathan Macy, Professor Mark Steinberg, and Attorney Norman Nickel. Turn it over to them. Thank you.
Good morning. I'm Mark Steinberg. Delighted to be here. I really want to thank Professor Marilyn Ford for organizing this program. It's a phenomenal conference. I'm delighted to be here. Thank the law review, of course, and the students for the wonderful welcome. And isn't this a beautiful room? I mean, wow. I mean, this is really impressive. I'm honored to be on this panel with really 3 other very accomplished academicians, practitioner, Professor Don Langevort, who I've known for, gosh, I really don't want to say how long we've known each other, Don. You know, we were both attorneys together in the General Counsel's office at the SEC, and of course is having a superlative career at Georgetown. And then to my right is John Macy, one of the foremost additional academicians in the country, in our area. Really, congratulations to both you. John's currently at the Yale Law School. And then we have Norm Nichols, whose greatest credential is that he's a graduate of this fine law school, who is an authority in securities law, practices at the SEC, and teaches securities law at Boston University Law School. Unfortunately, does not use my textbook in his course. But we'll still speak. That's okay, Norm.
Thank you.
So we're going to provide some thoughts on Texas Gulf Sulphur in addition to insider trading, although, of course, we have to talk about insider trading. My view is, and my view alone is that, I don't know if it's shared by others, is that this may well be the most important decision handed down in the securities law area in the history of the securities laws. And why do I say that? Well, with respect to insider trading, as we'll talk about, it's huge, but it addresses so many other issues involving the securities laws. Duty to disclose, when insiders can trade, the issue of materiality, culpability. We can go on and on. The list goes on with a number of issues. So we can look at some Supreme Court decisions like the Basic case, the fraud in the market theory, materiality, certainly a very important decision. That may arguably be the most important. Santa Fe, which basically said that breaches of fiduciary duty standing alone do not give rise to a federal cause of action. That's a very important decision. So, you know, arguments can be made for other decisions as well. I might add that I'm on the SMU faculty, and the Law Review, published the 50th anniversary issue for Texas Gulf Sulphur. We did not have a live symposium like we're having today. Nonetheless, the Law Review put out a fantastic issue celebrating the 50th anniversary in which many of the speakers here today wrote law review articles that were published in that issue, including Professors Langevort and Macy. So thank you for that. With respect to Texas Gulf Sulphur, one thing that must be really focused on with respect to this decision is that this federalized insider trading. And it's got a history behind it from the standpoint that insider trading until the early 1960s was solely a focus of state law, at least under Section 10B. Not under Section 16, of course, but under Section 10B. And Professor William Carey, who was a professor at Columbia Law School, he thought that this was simply bad policy, that insiders could simply have these secret profits with any type of effective enforcement regimen. It just so happened that Professor Carey was appointed chair of the SEC by President Kennedy, and he thereupon took upon himself a mission to find a case involving insider trading which the commission could focus on. And that case was Katie Roberts, where the SEC, maybe the SEC thinks it sometimes thinks that it's the Supreme Court, but it is not, where the SEC took the matter and recognized right away that case involved a very huge issue with respect to interpreting the federal securities laws. And the court adopted the access approach, basically, that those who have unequal access to information cannot trade on material non-public information until that information is adequately disseminated. That was the law that the SEC handed down, but as we know, federal courts, and especially appellate courts and the Supreme Court, frequently disagree with the SEC. And that's one of the reasons that Texas Gulf Sulphur was such an important decision, because it was really the huge case, the federal case, appellate case issued by the Second Circuit, in which the court recognized that insider trading was within the scope of the federal securities laws. And note here that many view the Sarbanes-Oxley Act, the Dodd-Frank Act, as the federalization of corporate governance. Yes, those acts certainly did reinforce that notion, but the federalization of corporate governance started scores of years ago. In fact, in the early 1900s, there were a couple dozen bills that were introduced that sought to have federal incorporation of large corporations or federal minimum standards. And indeed, when the Securities Exchange Act of 1934 was enacted, Section 16, which deals with insider trading, does federalize insider trading to a degree by the statute itself. For example, the statute says that when directors and officers and security holders who own more than 10% of an equity security purchase and sell or sell and purchase an equity security within 6 months, they must disgorge all profits in a lawsuit that's brought against them. And furthermore, Section 16 prohibits short sales by those individuals. So we see really substantive conduct that is prohibited. And then in 1942, when the SEC was headquartered in Philadelphia during the war years, the SEC promulgated the shareholder proposal rule, which of course is within state corporate governance all day long, and that rule now is over 80 years old. And now what we had with Texas Gulf Sulphur was the federalization of Section 10B with respect to insider trading, which of course is a very important part of corporate governance. And we're talking about federalizing insider trading with respect to impersonal trading on stock exchanges. Now, in Texas Gulf Sulphur, the court adopted the access rule seemingly, which basically says that those who have unequal access, directors, officers, for example, even the geologists, for example, they cannot trade on material non-public information and cannot tip material non-public information until that information is adequately disseminated. At times during the decision, the court also has even broader language dealing with the possession standard, that one who possesses material non-public information cannot engage in trading or tipping. That, of course, is not the law in this country after the Supreme Court's decisions in Chirilla and O'Hagan and so on. But nonetheless, what must be remembered that immediately after Chirilla, and Don and I were both at the commission at the time, the commission promptly promulgated Rule 14E3, which applies the parity of information rule, the possession rule, with respect to tender offers. So we really have a very dual type of regulation with respect to insider trading in this country, in that if one trades in connection with a tender offer, that's basically an offer by a bidder directly made to the shareholders of the target company. If insider trading occurs with respect to that, it's the pure possession standard. There is no duty analysis and so on. And the Supreme Court, at least in the context of the situation presented in O'Hagan, upheld the rule. So that the principles adopted in Texas Gulf Sulphur do survive in that context in this country. And moreover, Of course, I don't know whether foreign countries view Texas Gulf Sulphur and considered that approach, but the Texas Gulf Sulphur rule, either access or parity, is the prevalent rule in developed markets abroad. For example, the European Union embraces the parity of information rule, the pure possession standard, that was also given strong language of approval in Texas Gulf Sulphur. What about the timing of insider trades? The district court below basically said the announcement of the information permitted the insiders to go ahead and trade. The Second Circuit said not so. It's not only the formal announcement of the material information, it's that the information be adequately disseminated. And in that case, the court said that adequate dissemination meant that the information be disclosed through the means of broadest communication, which at that time was the Dow Jones broad tape. Moreover, in a footnote, the court stated that when the information is not readily understood, there must be some sort of waiting period, which should be left to SEC guidance to determine what is appropriate, which of course 55 years later, the SEC has continued to decline to act on this. Note, though, that customary corporate insider trading policies basically effectuate the standards set forth in Texas Gulf Sulphur, with waiting periods after corporate announcements, after the filing of 10Qs and 10Ks, and so on. What about materiality? The court did use the might standard, information that might be important to investors, which the Supreme Court declined to adopt, adhering to basically information that would be considered important to a reasonable investor, which is also contained in the language of Texas Gulf Sulphur. But I think the court's greatest contribution to the materiality standard was with respect to the probability magnitude test. And that is the greater the magnitude of the event, the less the probability. The greater the magnitude of the event, the less the probability. So let me just give this as an example to students who are in the audience, which I use at SMU, which really understands the concept. So I've got $1 here, and the situation is that we all stay in this room. We all stay in this room until tomorrow at this time. We can order in pizza, we can use the restroom, of course, but basically the floor is comfortable, it's carpeting. Enjoy, I hope you have a good night's sleep. And come around noon tomorrow, we'll have everybody's name in a hat, and a neutral party will pick out someone's name, and he or she will win $1. Okay, let's suppose there's 100 people here. Well, that means everyone's got a 1% chance, and I doubt if any of you will stay. But let's suppose rather than $1, I've got a certified check that's good for $5 million. For $5 million, the same rules apply, 1% chance. I have a feeling that many of us would be here tomorrow morning. And that is the magnitude probability test, and that is even though there may be a very slight likelihood of the event happening, 1 or 2%, the magnitude of the event is so huge, which was the mineral ore find in the Texas Gulf Sulphur case up in Ontario, that it meant that it was material. And note that this standard has been adopted by the U.S. Supreme Court in the basic case, and also, at least implicitly, also in the Matrix Initiatives case, decided, about 8 years ago or so. So that's another huge contribution to securities law outside of the context of insider trading. And then we go to the adoption of the negligence principle with respect to Section 10b liability. A question was asked last session regarding that the Supreme Court did reject that standard in both private actions and SEC enforcement actions, and private actions in the Hockfilter case and SEC actions in the Aaron case, and held that scienter is required, basically intentional or knowing misconduct. And practically all circuits outside of the forward-looking information context have adopted our recklessness standards, basically conduct that is so extreme that the actor must have known of the risk. So that's the standard. Yes, that's been rejected, but yet the negligence standard does prevail under the federal securities laws in other contexts. For example, under 17A2 and A3, the SEC, to some extent, has brought 17A2 and 17A3 actions based upon negligent insider trading. And I'll be interested, Norman, in your reaction why the Commission has not used 17A3 more so when fraud is uncertain that the actor acted with fraud. In other words, the Commission has brought a number of insider trading cases, not a lot, under 17A3, alleging that the person traded with negligence. That is an issue that's interesting, and also Section 13A, which the Commission uses in its enforcement actions with regularity, has a negligence standard. And then, of course, the proxy provision with respect to materially misleading statements and proxy documents, that's got a negligence standard as well. And then Don's going to talk quite a bit about company liability for misleading disclosure in the secondary trading markets. And the court in Texas Gulf Sulphur adopted a fairly broad standard that basically the press release that was at issue there must have been reasonably calculated to influence the investing public. So a fairly broad standard, which certainly encompasses nearly all corporate communications. And then the reference to timely disclosure. Texas Gulf Sulphur could have had better dicta. What I really view, which is not shared by certainly a number of others, is that there's a real huge gap in the U.S. disclosure system. And in countries abroad, generally speaking, like in the European Union, if information is material, it must be promptly disclosed unless there's business justification delaying disclosure. That's the rule. If information is material, like the loss of a major contract, it must be promptly disclosed unless the company has justifiable business reason. That's not the law in this country, as Texas Gulf Sulphur in a footnote implied, and that is the timing of disclosure is within the good faith discretion of the board and management, subject to SEC rules and regulations that require or mandate disclosure, and also if the company elects to speak, it must speak truthfully. Now, the stock exchanges do require prompt disclosure, absent business justification otherwise, but we know that the stock exchanges rarely enforce that rule. It's very rare, and of course, investors do not have a private right of action for damages for a violation of stock exchange rules. So in my view, we have a huge gap in this country where a company can basically lose a major contract and not have to disclose that until several months later. I'll end with my assertion that Texas Gulf Sulphur may well be the most important decision under the U.S. securities laws. As discussed by this panel and this conference, the decision focused on several important issues in addition to insider trading. Although a number of these issues have been rejected by the Supreme Court, many others remain good law. This decision also is significant from a comparative and international law perspective because several of its holdings with respect to insider trading and other issues have been adopted by developed securities markets outside of the United States. So on there, I'm delighted to next turn to Professor Langevord, who will discuss such issues as approaches to duty, principles, the in connection with requirement, and the fraud in the market theory.
Thank you. And let me add my thanks to the organizers who have done such a wonderful job putting this all together. I want to talk about some backstories to what's in Texas Gulf Sulphur, what led to Texas Gulf Sulphur, and where Texas Gulf Sulphur went after its decision. So I'm really leaving to everybody else here the deep dive into the particulars of Texas Gulf Sulphur. Obviously, it was a stunningly important decision. I think my backstories will underscore that, by no means undercut them. So let me take you through, and Donna mentioned some aspects of this. Let me tell the narrative, tell the story a little bit further. First of all, was Texas Gulf sulfur a surprise with respect to the egalitarian language, the egalitarian approach that so many people read into it? It's worth, if you're interested in doing the archaeology, to go back 3 years from Texas Gulf sulfur to a case called List versus Fashion Park. Let me read to you the language from List. Any narrower view, and it was rejecting the privity type approach, any narrower view of duty contravenes the purpose of 10b-5 in cases like this, which precludes not only the conveyance of half-truths by the buyer that actually misled the seller, but as well by failure of the buyer to disclose the full truth so as to put the seller in an equal bargaining position. That's what becomes Texas Gulf sulfur 3 years after that. Now this, as you could have picked up as I was reading, was a face-to-face transaction. And it is common to draw that distinction. But Judge Waterman, who wrote these words, didn't think that. He goes on to say, and any effort to limit the egalitarian rule to face-to-face transactions would open an intolerable loophole. You must extend, notwithstanding the common law's view of reliance. So that was the setup. Waterman wrote those words, and I think anybody pondering Texas Gulf sulfur as it's being litigated, who goes back and looks at List versus Fashion Park, will be, I think, duly warned of the fireworks that were coming. Second, and Donna did a lot on this, shortened my presentation a little bit, but that's okay. There is no doubt, and this to me is a fascinating backstory, there's no doubt that when Texas Gulf sulfur was decided and the insider trading matter became the centerpiece for reading and trying to understand Texas Gulf sulfur, there were people out there saying the Second Circuit didn't mean what its words say. The leader in that, as Donna pointed out, was David Reuter, who was a young, relatively, professor of law at Northwestern University, very much trying to make a name for himself and having chosen 10b-5 as his subject area. He wrote, and I have his words here, the one portion of the majority opinion suggests that the proper test is possession rather than some form of access. Most probably, however, the majority did not intend to establish the possession test. Not only did the opinion refer to special relationship in Caddy Roberts, but throughout the opinion, reference is made to the obligation of insiders rather than those in possession. Now, what a young David Reuter says about Texas Gulf sulfur may not seem terribly consequential. But as Donna mentioned also, it was at roughly this time that the American Law Institute chose to move forward with the Federal Securities Code, which would create express language on 10b-5 and all other matters of securities law, rather than leave securities regulations so much to regulation by enforcement and interpretation by reference to, as Adam pointed out, broad, largely useless ideas. The drafters, Milton Cohen, Louis Loss were the principal ones, immediately wrapped their arms around David Ruder's reading. And in a couple of years, the ALI drafters would come and say, the law of insider trading is the narrow view of the law that focuses on insider status. Any further than that should be left to future rulemaking or future determinations. In other words, the code became wedded to the idea that you shouldn't take all that language in Texas Gulf Sulphur so seriously. They had immense success. Dick Smith's concurring opinion in investor management very much drew from this idea, although he wasn't quite as restrictive in his understanding of insider trading as the Supreme Court would eventually come out to be. So he then left the commission and joined the ALI Code Project, where he was one more voice on this. Then, in a moment largely forgotten, and it's my job to keep repeating this, in May 1976, Phil Loomis, who argued the case in the Second Circuit for the commission, gave a speech that got a lot of coverage. Let me read the words from Phil Loomis's speech. Quote, "The concept of equality of information goes too far. It not only lacks an adequate basis in the law of fraud, but is an impracticable standard." That's a commissioner for the SEC joining Dick Smith, joining David Ruder, joining Louis Loss in what they viewed as a concrete wall against expansionism along the lines that we've been talking about. I take the position, and it would take me much longer than I have to elaborate it fully, that it was fair to say by 1976, the broad reading of Texas Gulf Sulphur had been demolished. Yet it keeps coming back up like a whack-a-mole in individual places. Why? I think the answer is because it was a good boogeyman. It was a good way to characterize insider trading if you were trying to undermine insider trading. And I think the various places, but when you go on, and this was discussed before, when you go on to look at the Second Circuit's Chiarella opinion, it doesn't say that equality of information, it disavows that. Yeah, it was useful, and when Justice Powell says, we can't affirm petitioner's conviction without recognizing, essentially, that possession equals duty to disclose. That wasn't right, but it certainly reflected some prevailing wisdom. Third backstory, and this is the one I'm supposed to talk about, so I'm finally here. In connection with the famous phrase that at once abandons privity as a check on liability under Rule 10b-5, and puts in its place that we are looking at the purchase or sale of the victims, not the perpetrator, in order to satisfy the in connection with requirement. And having done that, we premise liability on those statements reasonably calculated to influence the investing public. Reasonably calculated. That's really interesting because soon after, in the 1970s and then accelerating in the 1980s, courts were reading Texas Gulf Sulphur's language as one of foreseeability or proximate cause. Go back and look at the two words, reasonably calculated. That's about something having to do with intent, something having to do with what you're going to accomplish, not just do you see it having an influence out there. Now, I have mixed feelings about which of those articulations I think is preferable, but we shouldn't go too far without recognizing that in some sense, Texas Gulf Sulphur's words were twisted in the way the in connection with doctrine emerged. To my surprise, because I thought as the Supreme Court, as the judiciary became more conservative, they'd notice and pull back a little bit on in connection with. That hasn't happened directly, but for those who are close watchers of securities litigation, 10b-5 cases, something has popped into the law about in the last 5 or 6 years, which is standing. Prior to about 5 years ago, standing was seen as in sync with the in connection with requirement, in the sense that if you were within the zone of persons affected by people who speak in a manner reasonably calculated to affect you, you had a right to sue. You were within that scope. Then the Second Circuit began a series of cases that is still going on that says maybe that's right about the in connection with requirement, but forget about that. Standing is a separate and distinct notion. And the Second Circuit has said now 3 times that a lie, even an abject lie, does not confer standing to sue on the part of the victim if the victim is not an investor in the company identified in the publicity. That is to say, and this harks to shadow trading and things like that that are going on as hot subjects in the world of insider trading. If you, I'll take the Nortel case, which is the one that established all of this. If you bought or sold securities, and in this case, it would be bought in a company that supplies phones to Nortel because of what Nortel has said about its financial condition, you don't get to sue. Now, was it reasonably calculated or foreseeable that you would be misled? Absolutely. So here's the comeback to Texas Gulf Sulphur. It's not direct. It's a standing move. We're standing beyond the purchaser-seller requirement, had done very little work in securities regulation previously. Fourth, and I only have 5, so I'll be finished. Warn me soon enough. The duty to disclose. There's no doubt that one of the lurking issues that was not addressed but could have been in Texas Gulf Sulphur had to do with whether companies have an obligation to disclose material information in their possession, so long as, and Mark said this, Donna said this, I believe, you have an obligation. It is, you can call a timeout on the disclosure obligation if the information is not yet clear enough so that it's understandable when disclosed. But absent those excuses, there is a corporate obligation to reveal. This pathway, my second to last pathway, is an interesting one as well. It was Chiarella talking about insider trading that put a dagger through that supposed duty to disclose. How did it happen? Well, the insider trading portion of Texas Gulf Sulphur, as I said, becomes intolerable to too many groups and those who were fashioning the law. Justice Powell then chooses to use the fiduciary nexus, or trust and confidence, as the substitute for whatever you're reading Texas Gulf Sulphur is doing. And thus, a sentence in Chiarella says, without a duty, there can be no liability, and goes on to say, and that duty can be found, and most people read it, and only be found when there's a fiduciary relationship. Well, a few years later in Basic versus Levinson, the Supreme Court, dealing with did Basic have a duty to speak up, cites Chiarella, cites an insider trading case for this remarkably different context of speaking to the broad public marketplace. I have mixed feelings here too about whether it was good for that move to be made. Certainly, the Texas Gulf Sulphur footnote that references the duty to disclose without saying much more about it would be very hard to cabin. And there are all sorts of reasons not to have it. But the consequence of that Chiarella Basic move was to flip the law of duty to disclose into a place that itself is disturbing. Today, whether you have a duty to disclose is largely a question of wordplay, of whether the words you use are soft or hard, whether the words you use are in play rather than the subject of silence. The law dealing with the duty to disclose, to put it bluntly, is a mess. And I often wonder, and I have some opinions on it, what life would have been like had Texas Gulf Sulphur not led to Chiarella, and Chiarella would have left open the duty to disclose to develop on a more nuanced, grounds. If I got time for one last backstory, it goes back to David Reuter. A few years, it's 1972, a couple of years after the article I've been quoting from that is well known for what it does, David became convinced that Texas Gulf Sulphur's most pernicious effect was to open the door to liability based on Texas Gulf Sulphur's conception of materiality and intent and all that, was its impact on third parties, on parties who were not directly responsible for the fraud, but like lawyers, like bankers, may have had their hand in some form of disclosure that is challenged. David thought to have a secondary actor under an unclear scienter standard with reasonably calculated abandoning privity and creating liability out to the world at large was, in the end, the reason to reject Texas Gulf Sulphur and move on to the moves that the Supreme Court and other courts have given us. David really felt strongly about the risks being imposed on secondary actors. Or law review article in the University of Pennsylvania, the law review celebrated. That didn't have much effect until about 15 years later in the Central Bank of Denver decision. There, the Supreme Court quotes at length Dan Fischel as making that argument. But go back and look at Dan Fischel's article. Dan had just been hired by Northwestern, David Ruder's home, and he wrote the article that might as well be an extension of David's. So we can go Texas Gulf Sulphur to David Ruder to Dan Fischel to Central Bank of Denver for one more backstory, and now I'm done.
Thank you, Don. I like that you have the SMU Law Review reprint of your article in front of you. That's wonderful. Just for the individuals who don't know, Professor Ruder became Dean of Northwestern, and then he was appointed Chair of the SEC in the President George H. Bush administration. Professor Lewis Loss was a professor at Harvard Law School and wrote the prestigious seminal treatise on securities law. We'll next turn to Professor Macy. He's going to discuss the relationship between insider trading law and traditional corporate law fiduciary duties.
Among other things.
Among other things.
Thank you. It's really great to be here. I want to extend my profound thanks to the Quinnipiac Law Review, to Marilyn Ford and Jennifer Brown for organizing this. It's really a wonderful to be here and a great opportunity. This is particularly, there are a lot of great practitioners in the room, but we have Bob Thompson and Donna Nagy, Adam Pritchard, Don Langvort, Mark Steinberg, who are really giants in this field. So some of what I'm going to say is to provoke them a little bit, and hopefully they can further educate me. I've really benefited over the years from their articles and insights. I want to make a couple of points about Texas Gulf Sulphur and the law of insider trading. I will get to issues of traditional corporate law fiduciary duties, but the first point that I want to make is that there's sort of a standard account of the history of Texas Gulf Sulphur that I want to articulate and then reject as being an accurate description of the legal landscape of insider trading in the United States. So the standard account, which has a surface plausibility, is that, and this is, you go back to a very great article by a colleague of Mark's at SMU, Alan Bromberg, who wrote sort of contemporaneously with the litigation. The Second Circuit had written its decision, but it still had to go back to the district court for fact-finding and remand. It makes the point, which I think is right, that the more significant than any particular holding in the TGS case is the policy that underpins all of the holdings, which is, quote, an egalitarian idea expressed several times in similar phrases, that all investors shall have relatively equal access to material information, and that all investors should have equal access and should be subject to identical market risks. And so the standard of account of the kind of history of Texas Gulf Sulphur is that the equal access approach that we see Professor Bromberg so clearly articulating in his law review article is clear from the opinion, that the standard account is, okay, that gets rejected in Chiarella, and in place of equal access, we have fiduciary duties, we have an explicit rejection of the equal access to information theory in Texas Gulf Sulphur in favor of an approach on fiduciary duties, and that the court has said over and over, particularly in Dirks and Chiarella, that the basis for liability for engaging in illegal insider trading is not based on mere possession of informational advantage over one's counterparty, but breach of fiduciary duty. Now, what's wrong with this story? And what I will, my first point that I want to make is the problem with this story is that it doesn't contain any role for the SEC, right? And I want to say two things about the SEC in connection with modern law of insider trading. But my basic point is that we have two laws of insider trading in this country. One is the rules articulated by the U.S. Supreme Court in cases like Chiarella, Dirks, O'Hagan, Second Circuit, Newman, other cases, which are based on this fiduciary duty standard. But the SEC rejects that approach, I will argue, to this day, and continues to embrace the equal access to information theory. So let me mention a couple of points in support of my contention, but let me make clear that, so look at this from the SEC's perspective, right? Their view is we are the administrative agency with the statutory authority to interpret the securities laws. We're living in a world, not much longer, but we're living in a world of what I'll call a post-Chevron rule, right? The Chevron case says that a court should give a lot of respect to statutory interpretation, interpretive rules made by administrative agencies, and the SEC, clearly, is not happy with the law of insider trading as articulated by the Supreme Court. They prefer the equal access to information approach that was rejected in Chiarella, but was kind of won the day, if you will, in Texas Gulf Sulphur. Now, let's look at it. For one thing, just look at the Dirks case, right, where the Supreme Court literally chastises the SEC. They say, you're bringing up to us again, the court says in Dirks, the same equal access approach to information theory that we rejected in Chiarella. You keep doing this, and you should stop. But the SEC doesn't stop. Second point, well known, and Mark mentioned this in his remarks. What was the SEC's reaction to the Chiarella decision? It was to pass Rule 14E3, which basically says we are overruling, an administrative agency, are overruling Chiarella, at least with respect to a very important part of capital markets practice, which is tender offers. No requirement of fiduciary duty. All we care if you're in possession of material information about a tender offer, whether you breach a fiduciary duty or not. We are rejecting it. Then another data point is after Dirks, which specifically talks about market analysts, right? The defendant in Dirks was a market analyst, and the Supreme Court says there can't be equality of information where you have market analysts. Market analysts are going to ferret out and analyze information. And here's a quote from Dirks that it is in the nature of the kind of work that analysts do, and indeed of the markets themselves, that information cannot be made simultaneously available to all of a corporation's stockholders or the public generally. So we're rejecting sort of this the practical effect of equal access. And despite this language in Dirks, the SEC passes Regulation FD, which, just like 14E3, attempted to kind of mini overrule Chiarella. Regulation FD attempted to, and succeeded to a large extent, overrule the Dirks opinion. Another data point is the SEC's persistent litigation of issues related to the personal benefit test in Dirks. Basically, the SEC's position is that we should get rid of the personal benefit test, that if you're receiving information from a tipper with an intent to trade, you should go to SEC jail at least, if not real jail. So the idea is, the over the decades since Texas Gulf Sulphur, the SEC has never abandoned its affinity for the equal access approach. Now, I want to say this is not I'm not just necessarily, criticizing the SEC, maybe sort of a criticism if you think, Supreme Court precedent should be followed, but a lot of reasonable people sort of prefer the SEC's approach to the Supreme Court's approach. I'm just simply describing the sort of institutional position of the SEC, and this has real practical consequences, right? Because if you're, a lawyer, and there are a lot of real lawyers in the room, so correct me if I'm wrong, but my experience as, an expert witness in insider trading cases and following the field, that, if someone is interested in effectuating a securities transaction and they go to a lawyer for advice, right? The advice they get the advice they want to hear is not, well, you're going to be sued by the SEC and maybe indicted by the Department of Justice, but don't worry because you can litigate this to the Supreme Court, and based on existing precedent, you're likely to win, right? That's sort of not great legal advice. It's sort of more, well, maybe you want to structure a transaction so that, you're not going to be sued, or if this is purely academic. My point here, of course, is that the SEC's view of what the law is motivates the enforcement actions that they're willing to take, and they have this internal view of the rules that are much closer to the rules embraced in Texas Gulf Sulphur than they are to the more sort of Chicago school approach that you would see in Chiarella, Dirks, and certainly in the Second Circuit's Newman decision. So that's a kind of first point that I want to make about, kind of where we are, in the world of insider trading. There are kind of these two worlds. I think the SEC's approach, which is inconsistent in fundamental ways with the Supreme Court's current approach, and which much closer to the approach in Texas Gulf Sulphur. Second, a point that I want to make has to do with the maybe a little bit more normative. Has to do with the practical ramifications of equal access approach to information, or a fairness approach. So I basically want to motivate this with two basic observations about the nature of securities markets. So two very fundamental points. The first is that if someone has material non-public information about a securities price, so we have information, let's say hypothetically, like in Texas Gulf Sulphur, about a mineral discovery, right? And we think that the price of our stock in the markets doesn't reflect the true value of our company, because it doesn't reflect the value of all these precious minerals in the ground that we're going to exploit. The idea is that a trader's ability to profit from that information is very limited and finite, right? The share price, let's say, is $10 a share. When this information about this great discovery becomes public, the share price will go to $20 a share. And of course, once the share price adjusts to $20 a share, the basic point is obvious, right? Which is, well, then the profit-making opportunities from that information are over. So it's very limited and finite. It's not something that can be, is going to be enjoyed really by the entire sort of trading population. The second point, I think, a very fundamental point. This is a point that's been made a lot of times in the finance literature. It was made famously by Michael Lewis in his book Flash Boys, is simply the idea that if you look at the population of people who might engage in trading stock, that it's a very heterogeneous population. And that population is in no way, shape, or form equally or similarly situated with respect to their ability to profit on the basis of material non-public information that's not reflected in a firm's share price. And so, as a simple stylistic matter, what I've said in previous writings, that you could imagine that the trading population is kind of putting into three kind of categories, right? One category would be real insiders, people who are officers, directors, or investment bankers or lawyers in a company, and company A, to go to the Chiarella facts that Donna so ably described in her panel, company A is going to make an acquisition offer for company B at a significant premium over B's share price, and the ability to trade on that information before the information becomes reflected in B's share price is an extremely significant profit-making opportunity. So let's say we pass a law, insider trading law, which we've done, which prohibits true insiders, like a Chiarella or an O'Hagan or a member of the board of directors of the bidding company, from purchasing stock in the target. My point is very simple, which is that the consequences of that, from a distributional point of view, are not that the benefits of the increase in share price are going to be sort of randomly distributed among the shareholding population of the target company. Rather, if we block those insiders from trading, we pass a legal rule barring the insiders from trading, then there's a whole cadre of market professionals, right, of hedge funds operators, electronic traders, broker-dealer firms who have not maybe privileged access to the information necessarily, but privileged access to the markets, and will be able to be, the first people to go in and place the purchase orders and drive the share price as it goes from $10 to $20 a share. So, this notion that the SEC and the court expressed in Texas Gulf Sulphur that a ban on, I'm in favor of a ban on insider trading. I'm not in favor of insider trading. My point is a little bit more modest, which is simply that the gains associated with banning or regulating insider trading are not going to be randomly distributed among the shareholding trading population in a particular security, the gains are going to be attributable to, are going to be enjoyed by the kind of next best information processors who can take advantage of that information. So I tell my student is, imagine that I'm in a foot race, a 100-yard dash race. Macy is in this race, right? I'm running in this race. And I'm running against Usain Bolt, fastest person in the world, and the captain of the Quinnipiac University women's track team, and me. And so we pass a rule that bans Usain Bolt from running because he's a professional or whatever. And so it means that I'm still not going to win that race, right? That, again, the winner of that race is going to be the track team captain here, I can assure you. So, the same thing is true true with respect to insider trading. So I want to make that point. So that a couple of other points just to make about here is one with respect to the trading that occurred in Texas Gulf Sulphur, making a couple of quick remarks about the sort of corporate governance implications of the case. As far as I know, and those of you I think a lot of people here are more familiar with the history than I am, although I've looked into it. There were one important corporate governance issue in the Texas Gulf Sulphur case relates to the fact that this mineral discovery was made on a property to which the corporation, Texas Gulf Sulphur, did not hold mineral rights. Fact is well known. So a lot of the extremely long delay in disclosing information and the like related to the fact that before the company could benefit from this incredibly important mineral discovery, it had to secure the mineral rights from the landowners. And this is, two things about that. Number one, there is no argument that is made that nobody thinks that the sort of hyper fairness, if you will, that is being extended by the court to owners of Texas Gulf Sulphur securities should extend to the people who own this property, right? You get to withhold all the information imaginable from them. Second, of course, from a corporate governance perspective, is the point that I don't think there were any allegations that any of the trading that occurred in that case was kind of interrupted the efforts by the company or interfered with in any way the efforts by the company to secure the mineral rights. That the evidence seems to be, they stopped drilling, the people have talked about, they went to remarkable lengths, the company, to kind of hide what they were doing and not disclose things so that they could obtain those those mineral rights. On the other hand, this is it's a case involving classical insider trading. The idea that from a corporate governance perspective, the point of engaging in this exploration was to allow shareholders of the company to take advantage of anything that was discovered, of what was discovered, and the SEC's argument that engaging in purchases before the information was disclosed would deprive existing shareholders of the benefits of those discoveries. Now, that's true at some level of abstraction. I think it's far from clear in the case that, for reasons that Bob Fisk and others have mentioned, that, to the extent that the information was already out there in the marketplace, then even the SEC would agree that after that point, trading should be permissible. I want to mention one last thing. I don't know, how am I doing on timing?
I think you're over.
I'm over. Okay, then I'll stop. Plenty of time in the Q&A. Thank you.
Thank you. I'm glad that you have in front of you an article written by Professor Bromberg and my former colleague in the Southwestern Law Journal, which is published out of SMU, which in the late 1980s changed its name to the SMU Law Review. Professor Bromberg had an illustrious career. He authored the foremost partnership treatise in the country, as well as the foremost treatise on Rule 10b-5, a 7-volume treatise. And its license plate, I should tell you, said 10b-5.
Oh, wow.
That is what his license plate. I do have a photograph of it for those who want to see it. John, I just can't resist making one more point, which you know well, because you signed the amicus letter with Professor Bromberg in the Mark Cuban case that the SEC brought, in which I was fortunate to be Mr. Cuban's expert witness in that case. And that is Rule 10b-5-2. One aspect says that there's a relationship of trust and confidence if one covenants or promises to keep the information confidential. Mm-hmm. So if there's a oral or written confidentiality agreement or non-disclosure agreement, that by itself creates a relationship of trust and confidence.
Right.
As you pointed out in your amicus/brief letter, that may be a contractual breach. Right. But that one is negotiating at arm's length and signs a non-disclosure agreement, that does not give rise just by magic to a relationship of trust and confidence.
Right, fair enough.
You agree with me?
I totally agree with you, although I think
I'm
the
glad to hear.
practical implication, Mark, of that is that we just redid all the NDAs, right, to include a no trading provision. But in theory, I'm wholly 100% with you.
Well, the Second Circuit says, of course, in a number of cases, that it is a relationship of trust and confidence.
That's absolutely right.
The Second Circuit has sent people to prison based upon a breach of this.
Great point.
So next we turn to Norm Nicko, and the SEC, of course, has been criticized
I think
here
they have.
and elsewhere, and of course, as a very outstanding attorney for the SEC, having an outstanding career, you do good almost every day.
Thank you.
People should recognize the great benefit you do to the public by being a public servant. And for the students, I may add, if you really want a stepping stone to your career, you're going to be competing with people from Yale and Harvard and Cornell, and you may be every bit as bright as they are. You're not at one of those schools. It's like SMU. The students at SMU are not at Yale or Harvard. The government is a great equalizer. If you can get a job with a very good government agency like the SEC and do well there, the opportunities are going to be very, very broad for you. For example, Harvey Pitt, who we talked about, went to St. John's Law School. Ralph Ferrara, who I worked directly with when he was SEC General Counsel, he went to the University of Cincinnati. And they both left to go to major partnerships in national law firms. So keep that in mind when you're thinking about what am I going to do after law school. If you can get in with an outstanding government agency, that's going to be a wonderful opportunity.
Mark is 100% right about this, notwithstanding the negative things I said about the SEC. So.
All right.
What he says is absolutely right.
So what did I start? So I'm gonna start by giving my general disclaimer, which is any comments I make, of course, are mine, and they don't necessarily represent the SEC or the staff. And so thank you very much for coming. And I've got about 12, 13 minutes. If you asked my students at BU whether that was enough for me, they would say no way. So I'm gonna try to talk pretty fast. I originally, and I'm gonna talk a little bit about materiality, because to me, when I read Texas Gulf Sulphur, and I read it a lot, and I I read the cases that come after it. Materiality is really a big issue. I think it influences what we do at the SEC. We spend a lot of time on it. So I do want to get into that. But in light of the number of speakers before me talking about the SEC and talking about insider trading, I do want to, I'm going to try to get through a few things pretty quickly. The first is that I want everyone to think and realize facts matter. And sometimes it gets lost when we talk about the law and talk about the law. We could talk about the law all day, clearly, and we are, I guess, today. But when you are at the SEC or you are at the Justice Department, you are investigating facts. The facts matter. And I think that we heard from Bob Fisk when he was asked, why did you prosecute under these circumstances? It was because of the facts. The facts matter. And so we don't frequently spend hours debating the nuances of the federal securities laws when we conduct an investigation. We are looking at the facts. We are trying to determine whether they're misconduct. And of course, eventually, we have to test our conclusions. And those conclusions are usually tested in the courts. At times, they're in the administrative. But more or less, you know, we're talking about the federal district courts, the courts of appeals, and as we've discussed today with the Texas Gulf Sulphur, that is an SEC case. So let me go back a little bit and kind of talk about how we got to Texas Gulf Sulphur and a little bit afterwards from the SEC's perspective. So I think that what I can add here is, yes, Katie Roberts came out before Texas Gulf Sulphur. It came out in 1961, and it was an effort by the SEC to say, we are going to take insider trading seriously. And I agree, insider trading prosecution is important. There are people who will debate that, and they think, well, maybe we should legalize insider trading. I don't agree with that. I think that it's important for the integrity of the markets. I'm proud that I'm a part of that. I would certainly not agree if we watered down or eliminated the insider trading laws. Back in 1961, it was the view of the SEC that 10b-5 did not require intentional conduct or scienter. In 1968, when we had Texas Gulf Sulphur, it was still the view of the SEC, and the Supreme Court had not yet disagreed, that you did not need intentional conduct, you did not need scienter, an intention to defraud, to violate 10b-5 and the insider trading laws. Post Texas Gulf Sulphur, that changed. And so the SEC changed, notwithstanding some of the comments you heard. The SEC does change. The SEC does pay attention to case law. And by 1980, especially Justice Powell was tapping the brakes on the SEC's prosecution of insider trading laws and 10b-5. So this wasn't just, in my view, by 1980, with Chiarella and then Dirks and their progeny, this was not just about insider trading. The Supreme Court was tapping the brakes on the SEC's use of 10b-5. And so the SEC did have to deal with that, and we've heard about some of the measures they've taken, whether 14A3 or the misappropriation theory approach. With these kinds of facts in Texas Gulf Sulphur, regardless of how things changed after 1968 and with Chiarella in 1980, this would still today have been, the facts of Texas Gulf Sulphur would have led to an SEC prosecution, and it would have prevailed. That has, regardless of what you've heard today, it would have happened, the SEC would have won. And that's the case because the SEC would have been able to prove the scienter that was questionable in 1968. Has the insider trading laws changed a lot since then? Yes, they have. But is the type of conduct that you see in Texas Gulf Sulphur something that you would see in today's prosecution? The answer is yes, and I think successfully. The other The other thing I would say about insider trading before I move on to materiality is I heard one of my favorite securities right professors, Adam Pritchard, talk about O'Hagan. And at one time, I think he mentioned the disclosure that would be required to prevent fraud in the misappropriation context. And so I don't want to get too deep here, but what I will say is that the question of whether you can disclose away the fraud is a very important part. We haven't talked about it much. I don't know if we're going to get into it much before the end of the day. But from my view, from the SEC's view, or at least from my view at the SEC, I'm not speaking for the SEC, that is an important nuance. We've seen it. I worked on a case, and Adam knows this. I worked on a case, it's in his casebook, that dealt with this issue of can you disclose away your potential fraud or your insider trading? Could Attorney O'Hagan have literally picked up the phone and called up his law firm before he bought so many options? Did we talk about how much money he made, by the way? It was, and what I tell my students is, that's when $5 million was real money. So it was incredible. And what I also tell my students, by the way, is that it had to be the dumbest lawyer in America, because if you had half a brain, you would have realized that that kind of option volume that he executed probably was multiple times more than the average daily option volume for that stock ever. And so immediately, regulators, not just from the SEC, but from the exchange, would have seen it. And immediately they would have picked up the phone and they said, find out who just traded this. And once they did, he was done. So it really didn't take that case. That case didn't take very long. So I think that it's important to kind of think about the context of how we got here. There are obviously other important SEC insider trading cases that have happened since. Now, of course, the SEC does look at it as two-tiered. We look at it as kind of this classical approach, which we see with Texas Gulf Sulphur, and we see it in misappropriation theory on the other side. And so, I'm sorry, I'm going to make one more point on the misappropriation theory. So this disclosure to the source, it almost sounds kind of crazy that Attorney O'Hagan could have picked up the phone and called his law firm and said, I'm just about to press the button. Or, I've got my broker on the other phone and he's about to execute. And then hang up and not even wait for an answer. It sounds a little bit absurd. And so the question will be, what are we going to do about it? So we did have a case that looked like it was going to address that issue. It was in the First Circuit. I worked on the case. And I know I said before that we don't necessarily spend a lot of time talking about the nuances of the securities laws, but in that case we did. And what we did talk about, without breaching any confidences, what we did talk about was, what does disclosure in O'Hagan mean? What can we do? What can't we do? And what was sufficient? And so we talked about a lot of cases. We talked about how to make it work. But eventually, what you see in the Cubist case is this question that we raised, is that the disclosure can't just be disclosure. It can't be bare disclosure. It has to be useful. And in the Cubist case, the First Circuit talks a little bit about that, and about how our view was that useful disclosure meant someone, perhaps even including the SEC, needed to have the ability to do something about it. And so I'll just say one thing that I I think that it's important to think about what that could have meant in the Cubis case, where a CEO was supposedly told by his wife that she was about to tip her brother, who had a substantial amount of the stock, to sell it because they had just received bad news. The CEO had some options. And so the CEO could have called the general counsel. The CEO could have called the SEC. You're going to get a lot of defense lawyers to say that's a crazy idea, and that's not realistic, and that's fine. But there were a number of things the CEO could have done once he was told by his wife she was about to do something inappropriate. And so when you think about disclosure and meaningful disclosure, it's important, I think, to think about, can you do something with that information, and what are those options that you might have? All right, I'm going to stop there and quickly talk about materiality, and because I'm sure I'm down to just a minute or two. So when I first thought about Texas Gulf Sulphur, and I will tell you, when I discuss it at BU, the first time I discuss it, it actually has nothing to do with insider trading. It's actually materiality and this probability and magnitude test. It is fascinating. Love the test. Very meaningful to me as an enforcement lawyer at the SEC. It was followed by BASIC, and so someone asked me, how much do we still talk about Texas Gulf Sulphur? And the answer is not a lot, but cases followed Texas Gulf Sulphur, which arguably would not have happened without Texas Gulf Sulphur, and we talk about them a lot. And so those cases that come to my mind are BASIC v. Levinson and Matrix. Love those two cases. They're both in the context of not insider trading, but they're both in the context of materiality and how we determine whether something is material. And if you're wondering why we spend so much time on it, it's because 10b-5 says that to commit fraud in connection with the purchase or sale of security, it has to be based on a material fact. You either have to have misstated a material fact, or you have had to omit a material fact that, without stating it, it could cause the statement to be misleading. And so we spend a lot of time on materiality, and as a matter of fact, when we conduct investigations, at the end of the day, it may be where we're spending almost all of our time. What we call the P times M test is not only critical, but when I looked at Matrix, so Matrix came out, obviously, so if you timeline, right, Texas Gulf Sulphur 68, BASIC was 88, and then we had Matrix in 2011. When Matrix came out, really interesting case about the cold and flu drug called Zicam. And Zicam was a very popular drug in the early 2000s, and I know my wife used to take it. But some people complained that they were suffering from anosmia. And I will tell you, I didn't know what that word meant until I read the Matrix case, and now I know what it means. It means that you lose your sense of smell. And it wasn't happening a lot, but it was happening. Eventually, it kind of culminated, I think, in this Good Morning America episode, where people were coming in and explaining how terrible the drug was, what kind of effect it had them, and to lose your sense of smell. There was civil litigation, and it went to the district court, circuit court, and eventually made it to the Supreme Court. And the Supreme Court, in deciding what to do with these adverse events from taking Zicam, looked at the BASIC v. Levinson probability and magnitude test, which of course was originally in Texas Gulf Sulphur. It becomes a little interesting and complicated here, and obviously I'm not going to spend a lot of time on it. I'm going to try to wrap it up in a minute. But when you look at Matrix, while technically Matrix did not use the probability times magnitude test, there is no question, in my view, it is a balancing test. And just like the probability times magnitude test. And what are they balancing? They're balancing the actual adverse event. They're balancing how important is this drug to the company. And of course, in that case, it was 70% of sales. And they're also balancing, are people going to still take it if there's a certain percentage of adverse events? And with Zicam, it was really only for cold and flu. Of course, this is also pre-COVID. It was cold and flu. And so most people that would take it, they'd get over it in 2 or 3 days. And so the threshold then presumably would be very low, because you wouldn't want to take something to address your cold that would permanently lose your sense of smell. And of course, like I said, the emphasis is on, at the end of the day, what effect is this going to have on sales? Because that's what we're talking about here. We're talking about the capital markets. And if it doesn't affect sales, at the end of the day, it's really just not going to be material. And of course, with Zicam, it was a huge deal. All right, I know that I'm over. I'm going to stop there. I'm happy to be part of the Q&A and answer any questions that I can.
Still ready for you to buy Zicam at the CVS or Walgreens if you opt to do so and take that risk.
Hello, everyone. My name is Alexa. I'm going to be helping to moderate the Q&A portion of this panel. If you have a question, please raise your hand. I'll call on you. Panelists, if you could repeat the question into the microphone so that those tuning in on YouTube can hear the question as well. All right. Any questions? Yes.
On the Texas Gulf defense, our efforts in preparing our defense was heavily influenced by the officers and what they felt. And what they felt was that this was an extraordinary drill corps, but it wasn't material because it could have been down dip. You take my yellow pad, the 8 layers of the earth are layers of mineralization. If you drill right up this way and you hit a lot of mineral, it could all be very promising. But until you go crossways, you could be drilling down one of these. I'm sure I'm not explaining it very carefully. But all I can tell you is that we had all kinds of experts. Oh, we had maybe a couple. We had extraordinary effort in trying to promulgate the belief of the officers of the company that this could be a down dip instead of a cross dip, and that more drilling had to be done before. Well, as I look at it today, maybe we should not have been influenced so heavily by the officers, because the market probably wanted to know how good the drill core was anyway. He just explained this could be down dip and more drilling is required and all that, but at the time, we were heavily influenced in the preparation, the time we spent, the effort we spent, listening to our clients. Probably too much.
So I want just really quickly, the question related to materiality and the views of the officers of the company that it could have been bad news even, it wasn't clear. I guess, one thing I've thought about when looking at Texas Gulf Sulphur, and I don't know the answer to this, is if you're listening to your clients, I guess my question is, what's their story, right? Like, why were they buying the shares if they thought the news was bad? So I kind of criticize the SEC. I think the SEC is very professional, and I don't think they're at all corrupt, right? And so I think if you
That's a start.
I don't think they're all corrupt, but if you could say this is part of a pre-existing plan, or I bought the share, I think that would have might have pushed the SEC back a little in that.
Yeah, and actually let me add this. So because I've been thinking about this for a while. One of the important statements in the opinion that lives on is that when you're determining materiality, the fact in this type of context, the fact that the insiders were buying, how they were buying, and what they were buying, and when they were buying, was all probative to materiality. It was all really important. That lives on. We still see that cited from time to time.
Yes, right there.
Hi. For me, and I'm not an attorney, and I've had a wonderful time here listening to you all, this is similar to Pfizer is working with Moderna, and they're exploring a vaccine that might, be effective against a world pandemic, but Pfizer doesn't even own Moderna yet, and we don't know the vaccine's efficacy. So there's still so much, so it is all speculative. I mean, that is what buying and trading is about.
And that's right, and that's I'm sorry. The question had to do with the speculative nature of the facts we're dealing with in a case like Texas Gulf Sulphur, and that is the heart of the matter, and that's the heart of P times M. What we try to do is when you figure out materiality, you often have an event that hasn't happened yet. So the question is, how do we determine whether it reaches that threshold of being important to a reasonable investor? And Texas Gulf Sulphur said, and it didn't make a big deal out of it, Basic made a bigger deal out of it, that you look at the probability of the contingent or speculative event, and you look at the magnitude, and you may or may not literally multiply them together, but you come up with a kind of shorthand. And so, as Mark had mentioned before, if the probability is, what I probably don't usually say 10%, but if the probability is 25% that your company that's trading $10 on the New York Stock Exchange is going to get bought out by IBM for $100, and then that may be material. It is definitely material at a lower threshold than 50%.
But we have to be a little bit careful, right, when we talk about materiality, to say, when we're looking at the probability, I think you would agree that what's relevant is the probability at the time the trading occurs, right? And what screwed these defendants in Texas Gulf Sulphur was the fact that regardless of what the probability was when the trading occurs, it turned out this was a massive discovery. And so with hindsight bias, it looks like, well, obviously this was like, a huge event and highly material. And that's just a tough thing. It's just life, right? If you're a defendant, that in retrospect, it looks damn material.
Sure, but John, the test is the same.
Yeah.
We can argue about when you're supposed to execute the test, but the test is the same.
But also the point is that those who are transactional lawyers and give advice here, the lesson from this case is that you have to exercise caution with respect to your clients. It's a magnitude probability test, and if there is an important event that may occur, then of course counseling must be provided, alerting your clients and constituents of the client that he or she or it may be incurring a tremendous risk by undertaking the trading in the company's securities at that time.
Let's go here again then, Professor Ford.
Well, I just wonder, and I agree with that, it's all very well and good to pursue a case against insider trading, knowing what we know now, that the mine happened to, the fruit of the mine was terrific. I just am curious if it had done what the officers were saying mining can do and gone down or whatever and not been productive, would the SEC, and of course none of us know, but it is interesting to me to wonder if it hadn't been so successful, whether it would have been a case that the SEC would have pursued anyway, because at the time of the trade, nobody knew. That was, and you both answered my question.
Professor Ford?
I was going to go to the issue of disclosure, and of course Pete knows this more than I. In the Texas Gulf decision, the judge did say that the information, if not disclosed for a legitimate corporate purpose, and what was the legitimate corporate purpose? Two things were happening. The core that was taken off had been sent off for chemical analysis. That was number one. That's a
So I gather the question is that there are justifiable business reasons for not disclosing, so. So how would you deal with that now? I'll start this off, and that is that there's no mandated disclosure with respect to this event at this time. There's no affirmative disclosure requirements. It's unlikely that it's called for by a specific SEC rule. Perhaps it might fit into item 303, the MD&A, but you need a materiality analysis there of a different sort, and that looking at this with about a 15-second analysis, I would say that there's no duty for the company to disclose that information, and yet the insiders and others must maintain confidentiality and not disclose that information to anyone.
Yeah, and I'll just add on the MD&A, which is a subject that I absolutely love discussing. It's very relevant to what I do. Yes, so back in 1968, though, there was no MD&A, right? If I've got my understanding. So there was no MD&A. So today, what would happen is we don't have real-time, generally speaking, we don't have real-time disclosure obligations. There are event disclosures that need to be prompt depending on the circumstances under 8K, and there's a laundry list, and that's not static. The SEC adds them from time to time. But on a case like this, case like Texas Gulf Sulphur, the discovery, I do believe that they did not have an obligation to disclose upon discovery. They could have talked their way into it, and arguably they did, but they would not have had to disclose it until they had to, which meant SEC mandated disclosure. Today, they definitely, in my view, would have had to disclose it through item 303, which is the MD&A, because it talks about, are you aware of any known trends, uncertainties, events that will have a material effect on future revenue? So I think so it would then have to be disclosed at the next Q or K.
I disagree. At least I think there's a good argument, and that is the SEC has made an expression expressly for the negotiation of preliminary merger negotiations.
Yeah, sure.
If the disclosure is made as to those preliminary negotiations, they may, of course, become known and thereby scuttle the negotiations. I think the very strong analogy can be drawn to this case where affirmative disclosure with respect to this information may very well be detrimental to the company, and therefore there's a justifiable business reason that is ongoing that demands that secrecy be maintained.
You know what, though? It would have been really hard for them, with all of the disclosure requirements today, it would have been really hard for them today to make any disclosures in their next Q and K without walking themselves into securities fraud. It would have been today. It would have been really. In 1968, they clearly did not have an immediate disclosure obligation, and I think Texas Gulf, I think the Second Circuit obviously agreed with that.
You know, the strong analogy is to merger negotiations where CEOs basically get themselves into hotels at faraway airports and negotiate deals, and this can go on for several weeks and confidentiality is maintained. What we're talking about here is analyzing mineral ore finds and also buying up option rights and so on. It's very much analogous, and I would think that if the company could maintain its controls, which is a big if, that my position is that disclosure would not be required.
Well, disclosure would be a violation of fiduciary duties if it screwed up the acquisition of the mineral rights, right? Yeah. So, yeah.
It is a fundamental part of their business, though. So it isn't some unforeseen transaction like a merger that comes out of nowhere. It is different. It is their business.
So the SEC would require disclosure even though it would be detrimental to the company and its shareholders because of the loss of possibly...
Not even I'm that cynical.
Companies always say that. But
That's terrible.
Companies always say. Companies always use that as a defense.
I believe there's one more question, and then we'll... Okay, sure.
I think the footnote you mentioned early on also decision to disclose rests with the company and its board of directors, not with the insiders that have possession of that information, I guess.
All right, so the question was about the duty to disclose or abstain in Texas Gulf Sulphur. So sometimes it's easy to get confused about what duty of disclosure are we talking about? Are we talking about the duty of the company to disclose a potential material event? Or are we looking at the duty to disclose by an insider that is about to or executing a securities transaction?
Well, it seems like the duty on the inside is more to refrain from using that information to trade is really what it seems to say, because it seems to recognize that they may not be in a position to disclose that information.
And there is a
We
question.
kind of say it's a duty to disclose or abstain, but it's really more of an affirmative duty to abstain.
I think what you're saying is that it wasn't really a choice, according to the duty to disclose or abstain. They had to abstain.
And there was one more question down here.
It's not like me to be contrarian, but Don, I think you're wrong when you say that Justice Powell was wrong to say that you couldn't affirm the conviction without recognizing a duty to all the world. And that's because I don't think you could sustain the conviction given the jury instructions, which were very much Texas Gulf Sulphur unvarnished. That's what the jury received. And I think 8 out of the 9 justices agree on that point, right? That Chapman and Marshall thought there is a duty to the whole world, and therefore it's okay to uphold a conviction. But the judges and the justices in the majority thought, no, it wasn't enough.
Yeah, the question has to do with that key sentence in Chiarella about we cannot recognize a conviction here without it becoming so expansive that it all collapses on itself. I don't disagree with you entirely. I was objecting to the language used to describe that, which I think is overly restrictive. I was not commenting on whether I would overturn the conviction if I had difficulties with exactly what was charged.
But note here that we basically stand alone among the developed markets. And so far as I'm aware, every other developed market would have affirmed the conviction because Chiarella was an access person. He was a markup man at a financial printer who found out material non-public information before the public was aware of it. So he clearly had unequal access. He clearly was privy to that information, which the investing public was not. In the European Union, the parity rule, clearly liable. In Ontario, the major province for securities law in Canada, clearly liable under the access approach.
There's a big problem with that, Mark, and that's the following.
Well, let me just finish for a second, please.
You finish,
Yeah,
and I'll
of
tell you the
course,
problem.
of course. So please disagree with me. I have 3 children. And an ex-wife, I might add. I laugh at my own jokes sometimes, but that is true. But in any event, in every other developed markets, we had an individual who had a special status, who had material non-public information, and under the Second Circuit's law, Texas Gulf Sulphur and Chiarella in the Second Circuit affirmed that individual's conviction on the access approach, which would be the law, in my view, in nearly every other, as far as I know, every other developed market in the world today.
That comment is a little bit like the people who, in the 1950s, cited the Soviet Constitution and said, look at all these freedoms, they're much better than the United States, right? That is to say, you are right that on the books, Germany has a much tougher insider trading law than the United States. The EU has a tougher trading law, Canada does. The difference, though, Mark, is in the United States, we enforce the law, right? In Germany, there's been one criminal case brought in the history of the Republic. So, I think you have to look at, you look at insider trading enforcement in these other jurisdictions, and the United States is much more vigorous as a practical matter in enforcing the rules about insider trading. So we have to, it doesn't matter what the law says on the books if you're not enforcing it, right?
Oh, sure, no, I agree with you there. In fact, I made that point in a 2003 Law Journal article I wrote in the International Lawyer, that although other countries have a much more expansive insider trading and enforcement statutory or regulatory framework, they in fact episodically at best enforce the law. But nonetheless, just pointing out, we're law professors, so we can talk about theory and different approaches. That talking about theory and approaches here, under other developed markets, he would have been convicted under the excess approach.
I think that's all the time that we have. Apologies, but lunch is out in the lobby. If anyone wants to grab a bite, if anyone has any other questions, wants to come up and talk to the panelists, feel free. Forward.
And the point that we're going to make is that we have a beautiful facility here, and we purposely didn't set up a place for lunch. So you get your plate, you can come back in here. The law review students are here. They can direct you to the pond view. They can direct you to different places. And I'm sure the panelists would like to have you mingle with them and to continue the discussion. And I'll try to separate Mark and John during lunch.
I've learned a lot from this guy.
Thank you, gentlemen.
Thank you.